Good morning, everybody, and thank you for joining today's session. I'm Nicola McCormick, COO here at Pro Manchester, and today's webinar is hosted by Prosperity Law, and it will give you advice on handling and carrying out redundancy correctly. Following the session, I'll send out a post-event email which will contain any information about the event, including a link to a recording on YouTube where you can subscribe and stay up to date with all of our webinars. The email will also contain our feedback form, so if you could fill that in, that would be really helpful for us. Just a few points of housekeeping. Please be aware that the webinar is being recorded and feel free to use the chat function to ask questions. Also, as it's a smaller session, if you do want to pop on your camera and ask a question live, you're very welcome to do so. When you're not speaking though, if you could keep yourself on mute, that'd be really appreciated. So without further ado, I'll hand you over to David Hessian, Senior Associate at Prosperity Law. Thanks, David.
Thanks, Nicola, for that introduction. I'm just going to get my slides up. So today then we're going to be discussing redundancies really, and the steps employers can take in order to avoid redundancy unfair dismissal claims that may come about as a result of redundancy dismissals. So I know it's a smaller group, so I'm quite happy for people to sort of ask questions as we go along, or we should have enough time at the end as well to cover that off if there's any points people are unsure about. Presentation is generally aimed at HR managers, business owners, managers and so on. If you don't fall into that category, don't worry about it. The content itself should be quite straightforward to follow and shouldn't be too complex. I've not gone into massive depth in terms of legislation or anything like that. So hopefully you'll be able to follow and you'll find it useful from that perspective. Just picking up on the points then that we're going to be discussing and touching upon today. Firstly, I'll offer an introduction as to where we're up to in the general sort of economic climate in terms of redundancies and where we stand in that sense. Then through points 2 through to 5, they are points that the tribunal will assess when determining, whether or not a particular redundancy dismissal is fair. So in getting these areas right, we're really, protecting ourselves as the employer, and it will go a long way to ensuring we don't get any, either unfair dismissal or other claims issued against us. I've tried to sort of make this as practical as I can. So I've tied in, common issues that we might have with employer clients and practical issues that may arise from time to time. So hopefully it will help in that sense. Just by way of background, to give some context then to the overall presentation, the government job retention scheme then, as many people will be aware, is now currently, it's been extended until the end of March period. So many would say that that's helped avoid the deluge of claims that was expected at the end of back end of last month. So to an extent that may be true, although we'll come on to the statistics sort of further on in the slide. But the job retention scheme then, until this end of March period, will provide employers with some buffer really in circumstances where they've been impacted through COVID-19 with the overall intention of sort of avoiding job losses. So that is subject to review in January 2021. Currently, as many of you will be aware, it allows for employees to be paid up to 80% based on those days or hours that they're not working. So it operates, as I say, as a safety mechanism for employers in that sense. The review period, I think, will be dependent on where we're up to around that time in terms of the, managing to come out of the pandemic. There were other plans in place as well by the government under a job retention bonus scheme and a job support scheme as well, which have now been shelved as part of the extension around the job retention scheme arrangements. So quite frustrating from an employment lawyer's perspective if you've spent a lot of time sort of swatting up on these schemes for them to be sort of shelved really. So but that's where we're up to, and those have been superseded then by the job retention scheme and the extension around that. Some stats then around redundancy. So up to September period and in the quarter leading up to that period, we've had a record number of redundancies. So that's 314,000 redundancies in the quarter ending in September. So it's fair to say that in a record number, there's a big spike. In general, sort of historical terms, though, I would say unemployment rates aren't overly high. They're currently hovering around about sort of 5%, but projections are that they will move up towards 7 or 8%. Bank of England projections are that they will move up into the course of early next year. So it's fair to say, unfortunately, we can see this as a kind of continued pattern where there'll be more redundancies coming into early next year. And it's hoped that in that context, this presentation will be useful to those employers who might be in that unfortunate position where they do have to, carry out redundancies. Of course, not a nice thing to have to do in any organisation, but where you do it, and if you do it in the proper way, you may be reducing, your liability in terms of attracting unwanted litigation. So just on the next point then on the slide, I've outlined the statutory definition for redundancy. Okay, so it's the first point we have to look at and get home on, really, if we're going to demonstrate that our redundancy dismissal is fair. And it can come about really in two ways. So the first one, the very typical scenario where you've got a factory or workplace closure or a business closure, which would probably be the most commonly associated method or means of redundancy, if you like. And then the second aspect, which involves is a bit more to it, that's diminution or cessation of work of a particular kind. So it might be the employer, has the same amount of work on their books and they want a lower number of employees to carry out that work. It might be that they've just got a genuine drop off in terms of, customer orders or their levels of income and so on. And there are a number of grounds of redundancy through which, or grounds of dismissal rather, through which an employer can dismiss an employee fairly. Redundancy is one of those grounds, but you need to fall within one of those reasons if you're going to demonstrate that the reason then for the dismissal was potentially fair. So I've just drawn some sort of practical points then on the next slide from that. So first point being the reason around redundancy can be a fairly straightforward hurdle to overcome. What I mean by that is the employer is not necessarily required to justify its decision to make an employee or employees redundant. It might be, for instance, or for example, the employer's being particularly wasteful in bringing it before the redundancy decision was taken, so they've maybe not managed the finances in the way they could have done. And that's brought about this redundancy situation. Now, it would be a common argument for the employee to sort of jump up and down and say, well, that's massively unfair, really. The background behind it's unfair. The employer didn't conduct themselves in the way they should. A tribunal won't necessarily get into that. So the employer is not required to justify the reasons for redundancy. You just need to demonstrate that the redundancy reason in itself exists and that the dismissal has then flowed from that reason to get home on the first point then around having a valid reason around redundancy. So any decision should be supported by a business case with evidence to substantiate it. So, it's quite common the employee may argue that there's more sinister motive involved. They might put forward a discrimination argument in saying, the redundancy and the reason for the redundancy is all a bit of a fad and it was just a way of removing someone from the business. So in having a good, cogent, detailed written business case from the outset, the employer is able to sort of gainsay and get away from that argument. Some potential pitfalls then that I've outlined around that point where employers may perhaps fall down on that point. So it might be you make a role redundant and you sort of very shortly after that go and recruit into that role. So that would obviously go against any reason you put forward for redundancy if you're trying to argue, against an unfair dismissal claim. If you're just getting rid of an individual and appointing them into somebody else into the role straight after, that goes against that. In scenarios like that, we would generally advise employers on a buffer period of, say, sort of 5 to 6 months, through which there's a sufficient period of time and through which they're then going in and appointing somebody else. So that's just something you need to be mindful of as an employer. And in restructure scenarios on a similar level, where you've got sort of new roles emanating from your existing roles that are very similar in nature, you'd need to be careful that they're not too similar in the sense you're taking away from your redundancy arguments. So when it comes to, putting forward new job specs and things like that, you're making them substantially different to the old roles. So you can justify your redundancy argument to say, well, look, that old role has legitimately gone. So again, there's just a couple of pitfalls you'd need to maybe look out for as the employer on that point. So once we've got then our reason for redundancy, the next point would be around the selection. And what we want to look towards as the employer is to have a suitable selection pool. And in some respects, I think this can be a difficult area for employers. The legislative basis for it and the legal test is that, look, the employer just has to have a good think around whatever pool you select. So you've got to do that in a way that's generally fair. And, it's a balanced decision in that sense in terms of what you're taking into account. So we don't have a stringent blueprint or legal test in terms of which number of employees you should select for the redundancy process. So that can, in some respects, give employers a wide discretion, but can also make it quite difficult for the employer. But I think whatever decision you take in terms of your pool, you just need to be in a position where you can justify that with a good sort of solid business case in order to sort of get home on that kind of particular issue around selection. And selection, bear in mind, is one of those areas I think that is most commonly challenged by employees in the context of redundancy. So it's probably the most common area, which from an employer's perspective is likely to come under attack from the employee if you are subject to, from either an unfair dismissal or a discrimination type claim through a redundancy dismissal scenario. So I've set out individual selection may be justifiable in some circumstances. So, it might be if you've got a very specialist confined role, you would select somebody on an individual and automatic basis, which I think would be fine and acceptable, assuming you can justify that. Where you would have to be careful is where we've got interchangeable roles. And I think with employers in this area, there is a very much temptation to go down a sort of narrow approach of making the pool as narrow as possible. And that's understandable because, firstly, you're creating more work for yourself and having a broader pool. And I think second point is you don't necessarily want to involve any more individuals than they have to as part of the redundancy process. So that lends itself to maybe a narrow pool and having maybe a pool of, for instance, 6 or 8 employees as opposed to 10 or 12 that you're going to select from. Just be mindful, though, as the employer, the more narrow you make your pool, in some instances you can then expose yourself a bit more in terms of, the unfair dismissal argument. So the next step, once we've identified the pooling arrangements, we'd need to sort of carry out an appropriate scoring exercise. So we need to be fair and reasonable in the way we go through our scoring. The traditional method that would have been used around this approach some time ago, and it's not the most favoured method now, but we would have had a last in, first out approach. So those employees last in or with the lowest levels of service are the first out and first selected around the redundancy. That's seen as an unfavourable approach now. A couple of reasons for that. I think just generally that is going to be seen as quite a crude and sort of lazy approach from the tribunal's point of view, and they are likely to hold that could be unfair dismissal if you're not taking into account other criteria that we've set out really on the slide. And I think it can give rise to quite obvious age discrimination claims because those employees that are last in are inevitably and disproportionately going to be younger members of the workforce that have least experience. You give rise to a very obvious, I think, age discrimination claim where you do that. So I've sort of set out then on the last point of the slide, those typical criteria that we would use in applying the matrix scoring system. I think from an employer, if you're going to step outside that, you need to give a reason why, so that we're not just, seen as getting rid of an individual because we don't particularly like them. So you'd have to try and be as scientific as you could in sticking to sort of tried and tested criteria. I think within that, there'd be some degree of discretion. So for instance, if you wanted to use a scoring of say 20% and you wanted to weight it on that basis as opposed to 15, that would be sort of acceptable from the employer's perspective. You would have that degree of discretion. Next point then around selection, I've just highlighted some sort of common areas where, you could go wrong in terms of the scoring. So it follows that on a sort of particular scoring exercise, then, if we're scoring somebody on mat leave, obviously if it's around performance or attendance or something of that nature, we score it against the period of time they've been off on mat leave. That's going to give rise to a very obvious form of, sort of sex discrimination claim that we would want to avoid. So quite common in that scenario that the employer, would assess scoring based on the 6 to 12 months prior to the mat leave period, which I wouldn't advise against. I think that would be acceptable. Some employers will just take a blanket approach of, if an employee's on mat leave, we'll just exclude them from the redundancy process. I think you need to take some care on that front if you're going to do that. It can lead to sex discrimination claims from male employees. That's the first point. And even just general unfair dismissal claims if you're going to take that blanket approach of excluding employees on maternity leave. As I say, to some degree, it's understandable why employers might look to do it, because they're maybe scared of a heavy discrimination claim coming from the pregnant employee. But you do need to be careful just in doing that when it comes to applying scoring exercises. The other issue then is where you've got a common issue that can arise around scoring exercises, where you've got an employee who has a disability. So they might have a disproportionately high period of absence or rate of absence as opposed to other employees who don't have a disability. So we have to be seen to be taking that into account when it comes to applying our scoring. And when we're dealing that, you might get a steer from occupational health to determine whether or not particular absences are not sort of disability related. So it's important that when we apply our scoring, we're at least taking those factors into account. The second point then, we should act fairly in terms of applying the scoring. So trying to avoid an opinion-based sort of subjective approach. And I think that's quite easy to do when it comes to measuring things like attendance or, grievance or disciplinary records. That's a lot more measurable, and we can tie that to sort of tangible, measurable information that we've got on employees. Performance, I think, is a slightly more tricky one because it lends itself to more subjective, typically, I think, assessment. So you just need to be a bit careful on that. So if you're an employee or employer rather who undertakes regular appraisals, it's a good idea to just sort of tie them to the scoring mechanism that you use through performance. That helps you then sort of fight off any argument from the employee that you're just generally acting unreasonably as the employer in terms of any scoring that exercise that you've undertaken. So worth bearing that one in mind. Try and always, when you're conducting your scoring, to the extent you can, and it might not always be possible, particularly maybe with smaller employers, but try and sort of tie it in and make it consistent with measurable, tangible information you've already got on the employee. And it gives you a more robust argument if there's an unfair dismissal claim and scoring is put forward as one of those arguments by the employee. And it follows then and leads us on to our next point, that employees should be consulted on the proposed scoring system that you intend to take and given an opportunity to then input on their scores, where you apply scores or the criteria to a particular employee under the process. As I said, that leads us into the next aspect, I suppose, we would have to deal with as the employer to demonstrate that your redundancy dismissal is fair. And it focuses around the notion then of consultation and having individual consultation with the employee. And I've outlined in the first sort of point of the slide that inevitably, if you're just not undertaking any degree of individual consultation, inevitably that's going to be taken to be unfair dismissal. So just be conscious around that one. Level of consultation expected will depend on the facts. We'll come on to it slightly later in the presentation around the steps that I would expect employers to undertake. But I would always say, and again I'll come on to it, as a bare minimum, I would look for sort of 2 individual consultation meetings to be held by the employer. I think there's some circumstances, yes, you might get away with sort of conducting 1. Other circumstances, more complex redundancies, you might look towards 3 or 4 individual consultation meetings. As a broad rule of thumb, you want to work towards a bare minimum of 2 individual meetings, and they should be meaningful. So bear in mind, the purpose of the whole consultation exercise is to explore whether there's any scope for avoiding the redundancies. So yes, as an employer, of course, you've probably already considered alternatives. Otherwise, you wouldn't be in a position where you have to go down the redundancy route. Most employers, will look to only go down the redundancy route as a last resort. But where the employee comes up with proposed suggestions around whether it be voluntary redundancy, reductions in pay, or hours of work, it's important from the employer's point of view that we're at least projecting that we've taken those proposals into account, and we're not simply sort of scoffing at the employee's points or ruling them out of hand. So just be, I think, aware of that. And then the next slide, sort of coming on to the consultation steps then that we would look to take in any typical given, redundancy dismissal scenario. So whether I was acting for or I'm acting for employer or employee, I'm generally going to, look towards these points really as points that should be followed by the employer as part of any sort of redundancy process. First point, really, warning letter to employees setting out the redundancy proposals. That could form a warning meeting as well, but we would at the very least want to present in writing, the reasons for the redundancy, why they're happening, what those proposals are in terms of pooling arrangements. And it's useful at this quite early stage in the process as well to set out what your proposed, scoring mechanism is going to be, whether it be through a matrix, for instance. So we're setting that out at an early stage. Puts us in a stronger position from the employer's perspective to again fight off any claim or any arguments that the employee may have. We will say, we've set our stall out at an early stage. You've had ample opportunity as an employee to sort of comment on and consult around any sort of scoring proposals or mechanisms that we may have. Then in the individual meeting, I would allow for probably 3 to 4 days typically after the warning goes in. We would have the individual meeting, but we typically discuss issues. Doesn't necessarily have to follow that we are discussing these issues, but typically we'd be discussing issues with the employee around whether there's any, on an individual level, whether there's any ideas or thoughts they may have in terms of avoiding the redundancy process. And if we have scored them at that point, we're discussing sort of provisional selection with the employee as well. So it's important we have those discussions, as I say, I think through an initial individual consultation meeting. Then we're typically allowing for, I would say, 7 to 10 days. So we've got a suitable enough time frame to be then moved to our second meeting. So we've allowed enough time, for the employee to consider the proposals that the company's put forward, and then they've got a chance to input and come up with any suitable alternatives that they may want to come up with. And that leads us into our second individual consultation meeting, which typically might be a bit more finite in nature. So we're discussing things like, their statutory redundancy entitlement, issues around suitable alternative employment. Redeployment is another important aspect we need to sort of deal with, which I will come on to in a moment. But that's something that needs to be sort of ticked off. And also confirmation of termination followed by the right of appeal. So there has been some case law on this to say that, strictly speaking, employers don't necessarily have to offer the right of appeal in a redundancy type dismissal. I would still advise on it because I think as a general point, it just conveys that the employer is being, quite reasonable in its approach. And I think secondly, if you offer up the right of appeal and the employee doesn't exercise that right of appeal, you put yourself in a stronger position then as the employer if there's any subsequent claim for unfair dismissal. So it might be typically, the employee presents a claim for unfair dismissal saying, that was hugely unfair. We will say as the employer, well, you had your right of appeal and you didn't exercise it. So it's a useful, it's a useful argument we can then advance at that stage. I've just set out as a bit of a health warning. These steps aren't by any means set in stone. Each case will be different. And of course they will be variable. But I'm just setting out the broad framework in terms of, what I would expect to be covered as part of any redundancy dismissal. And some sort of practical points then I've drawn from that. So it follows as an obvious point then, you should be taking detailed notes at each stage of the process. Some employers will go to the length of trying to get notes agreed with employees and so on. I'd say that's slightly excessive, but we need a detailed written account at the very least. to document what's going on in the consultation meetings. Recordings, nothing to stop you as an employer taking recordings, but it follows then you need to be very careful in terms of what you're saying. Discrete recordings by employees, that's been known to happen, and that can be taken as admissible evidence. So again, it's a bit of a warning sign, I suppose, for employers. Just be careful that you're not saying anything you shouldn't be in the context of your formal redundancy consultation meetings. Some employers may well adopt their own formal policies and procedures. I've seen my experience, in particular sort of local authorities, have very detailed procedures. I think that's a double-edged sword on that one. If employers do have detailed and comprehensive procedures, yes, it helps in terms of, you give management a blueprint in terms of how to go about the redundancy, but you also, conversely, you alert the employee to, maybe some potential arguments that they might have if something is flagged up in the policy. So I think particularly with some employer clients I would have where they've not got employer policies and procedures, you might, I'm not necessarily advising that's a bad thing really, because it doesn't prevent them anyway, of course, going through a legally compliant sort of policy or procedure in terms of carrying out the redundancies. So that I think takes care of the policy and procedure aspect around redundancies. Meetings, I think certainly pre-pandemic, there would have definitely been an expectation where they be conducted face-to-face. Now I think virtual platforms around Zoom, Teams, obviously becoming a lot more commonplace. I don't think there'd be any issue with that. It'd be interesting to see whether they become the sort of accepted norm once we come out of the pandemic. Quite possibly. I think there would still be some expectation to have individual face-to-face consultation meetings where it's possible. Telephone calls, I think certainly in the current climate would be seen as, I think, an appropriate method of communicating with your employees when it comes to the area of consultation. Last point then on the slide, that employees should be given the right to attend meetings with a trade union representative or colleagues. So quite a strict test, that one. It's quite common the employee will advance an argument to say, well, I should attend with a family member or even a legal representative. In certain sort of exceptional circumstances, which I can't really see it applying in a standard redundancy scenario, yes, that might be allowed. But broadly, that is a strict test. So if you wanted to take a robust stance around that as an employer by saying, look, no, it's trade union representative or work colleague only, I think you would be, fully entitled to do that. A further then slide I've just included in terms of some circumstances then where the employer may be obliged to collectively consult. So there's added obligations. Note that they don't replace the individual obligations to consult, but in certain circumstances where you trip over a threshold of a certain number of employees, there's an obligation to consult collectively with appropriate representatives of those affected employees. So typically that involves, giving those representatives information from the outset on the proposed redundancies, and also, consulting with them as part of the process. So it's important to note as well, when we talk about one establishment in this sense, we talk about one specific geographical site or location. So for instance, if the employer is proposing to dismiss sort of 50 employees across 5 different sites, 10 employees in each site, that wouldn't necessarily trigger the collective obligation. Once we're into 20 or more employees on a particular site or location, that's when your sort of alarm bells should start ringing as the employer, to trip into your collective consultation obligations, really make sure you comply with that. So employees number, as I discussed then, employees numbers are based on specific locations. And it's important to note that where this obligation isn't followed, employees can bring what's known as a protective award or claim. So that's a claim for 90 days pay based on gross actual pay. And where you've got a large number of employees, sort of 50, 60 employees, and that may all be claiming for that, you are talking about potentially a very heavy liability from an employer perspective. So it's important that we're covering off then our collective consultation obligations, as well as in addition the individual ones as well. So that covers off then the reasons around redundancy, selection, consultation. all aspects of redundancy, redundancy dismissals, we'd have to address properly from the employer's perspective. The sort of next one and final one to make sure we cover ourselves then would be around redeployment. So as an employer then, we have to give consideration to whether suitable alternative employment exists within an organisation, and we'd have to then look for work then, or do a reasonable search for work. Now in practice, that is going to involve at the very least notifying employees around suitable alternative vacancies. Now what's suitable can be quite a subjective test, really. What I might deem as suitable would be different to somebody else. Quite commonplace for employers to just take the approach then of notifying the employee of each and every vacancy that they've got in and around the point of the redundancy process. So, and I wouldn't necessarily advise against it. I think that's probably not something that's going to incur a lot of time from the employer's point of view. And you are then, definitely sort of boxing off at least that obligation to notify the employee around suitable alternative employment. So you're covering yourself on a sort of belt and braces approach in that regard. I think there's a danger if you just sort of make an assumption or take a view that the employee might not deem a particular vacancy as being suitable. That could come back and bite you further on down the line. The employee might run an argument to say, well, you just jumped to that assumption, and without consulting me, I may well have taken that job, whether that's sort of genuine or not. So from an employer's angle, you might want to just box that off. As I say, it should be a fairly easy exercise to just notify your employees on every single vacancy that you've got available. It follows then, following on the next slide, just around redeployment, that the employee should be given enough information then to weigh up and take that decision around, whether the role is suitable for them. So that, again, should be a relatively straightforward exercise. Where you've got job vacancies, typically employers will already have, sort of person specs and job specs anyway. So that should be, an obligation that's quite easy, to discharge. I think where you might fall down on that one is obviously making, quite informal oral offers around alternative employment to your employees. That's where you need to take some care on that one. And where then more than one employee, which can be quite common, so if there's 2 or 3 employees put themselves forward for a particular vacancy, you should then, and I think employers would have quite a large degree of discretion in this area, you should apply suitable selection methods. So it might be, for example, that you're using a scoring system around, similar to a matrix system that we've discussed around the selection. If it's a more senior role, for instance, you might want to take a much more robust, rigorous approach as the employer by, applying a more sort of stringent test around assessment days or interviews and so on, and dealing with it that way. I think you would have a fairly large degree of discretion around what method you want to use, but it's important that whoever we're selecting for the suitable alternative post, we have, put forward a good business case for that, and we can back that up and we can sort of justify the business case really behind that. Important point to note then on the last point in the slide, and this is one area where employment law sort of puts forward or projects positive discrimination. So where we've got employees who are undergoing mat leave or maternity leave, and they are part of the redundancy process, they've been selected, they are have to be offered suitable alternative work as a sort of preference, to the extent that exists. So applying the example, sometimes this is difficult for clients to sort of comprehend, but if you've got 3 people going for a role and there's 2 people that are maybe on paper better suited to that role and they may come across as better candidates, the individual on mat leave or maternity leave, is assuming they can do that role and undertake that role and it's suitable, she would be entitled to be offered that role ahead of other candidates. So it's one area where we see positive discrimination really in operation, and it is set out in the maternity regulations. So I'd say just be mindful of that, where you've got employees on maternity leave and suitable alternative work comes up really as part of through the redundancy process. So just on the next slide, again, continuing on then on redeployment. First point I sort of already touched on, that we should be making then suitable arrangements then for any employees who express an interest in alternative employment. Certainly advertising externally or putting the job out externally, I think you'd need to take some care on that from the employer's perspective. I think you'd certainly have to go through that internal process first, at least in sort of ring fencing or making the opportunity available to internal candidates to the extent they want to put themselves forward. There is a very natural temptation to just put a role out externally, and I think that's understandable, because in doing that you have a greater chance of getting a suitable candidate for the role. But just take some care on that and make sure you're ring fencing your employees internally, and we're making it available to employees internally. Yes, it may get to the point where we don't have any suitable alternative applicants, and that will then free you up to go via the sort of external route, if you like. But just be careful you're going down that road initially, rather than going straight in and sort of advertising externally. And refusal to offer suitable alternative employment, which we'll again come on to further on, could amount to sort of unfair dismissal as well, depending on the circumstances. So what we wouldn't be obliged to do as the employer is to sort of offer up a special role or carve out a special role for the employee as part of our redeployment obligations. That would be seen as too onerous on the employer. And yes, to the extent suitable alternative employment exists, we would have to consider that, potentially offer to the employee, depending on the facts. But we're not obliged to sort of carve out special roles for employees where they don't exist. Sometimes employees can be under that sort of misconception around that. So again, it's just a point to be aware of. In certain circumstances, and this may apply, I suppose, to you if your employee, has a particularly lengthy period of service and has potentially quite a large entitlement around their statutory redundancy payments. In certain circumstances, if they refuse suitable offers of employment and they are seen to be unreasonably refusing those, they can forfeit the right to the statutory redundancy payment. So we've got to make sure that the offer then is made before the termination date, which makes sense. You can still go ahead and offer suitable alternative employment after that termination period, but if we're doing it after that point, we've got to accept and appreciate that the employee is then within the rights to reject without that impacting on their statutory redundancy payment. And around the 4-week trial period, then that will operate sort of automatically. So it's still best practice to notify your employees that the 4-week trial period will come into effect. Obviously, the purpose of that then is to allow the employee to sort of gauge whether or not the offer of suitable alternative is reasonable or acceptable to them. And 4 weeks, as I say, as the statute sets out, should be a reasonable period to enable them to do that. I've set out some factors that will be taken into account, when assessing whether the employee is acting reasonably in rejecting suitable alternative employment. It is by its nature, case law position, it is quite a strict test. And the test is twofold in nature. So whether the offer around the role is suitable forms an objective test. So very like-for-like comparison around old job and new job, if you like. And then whether the employee is acting reasonably in refusing is more of a subjective sort of opinion-based test. And it's based on those factors then that I've sort of outlined on the slide around status, pay and benefits, hours, location, and so on. It is, as I mentioned, quite a strict test. So to the extent there's any drop in the level of pay, even through a sort of pay protection style arrangement, I think the chances are the employee would be well within their rights to reject that and still, retain their rights to the statutory redundancy payment. So that deals with everything really, I think, in terms of the overview and the broad steps that we need to be taking as the employer to sort of reduce those risks of claims being brought against us. As I say, if you stick to the principles outlined there around, firstly, having a genuine reason for redundancy, then into selection, consultation, redeployment, really sort of ticking those boxes. There's a strong, probability and likelihood that you are, going to at least reduce that risk of any claims being brought against you. And even where claims are issued, you're in a position then where you've got a robust case, and you can even, if you want, if not going forward to tribunal hearing, you can settle your claims on a commercial basis, for not that much money. So you're putting yourself all around in a stronger position from the employer's point of view. So having dealt with the issues you should tackle then, and addressed properly in terms of, again, selection, consultation, redeployment. I've just set out in the next slide, precisely what the risks are, and offered a bit more sort of detail in that sense, just so you're mindful of, those risks that could come about if you fall foul of the process or don't go about the redundancy process in the way that you should. So in the event claims are issued, it's likely to lead to costly and time-consuming litigation. It sort of goes without saying, if you're going to a final hearing, tribunal hearing, it's going to be, you're going to incur substantial legal costs around that. And you've got the fact that you'll have employees typically will have to give witness evidence, taking a lot of time out of their day or days. And it just becomes a time-consuming process that you don't want. So you're well advised to, carry out the correct process from the outset, and if needs be, if you feel the need, obviously take legal advice within that. Most common claim then is around unfair dismissal. So two particular aspects to that. You've got your basic award, which is calculated on the same level as on the same basis as statutory redundancy payment. So it's number of years service times gross weekly pay. Current cap on that is £538 per week. And then the compensatory aspect then, which is the lower end of 52 weeks gross pay, or £88,519. So that gives you an idea as to what you might go for. And a lot of it will depend on the findings the tribunal make. They might in some cases be reluctant to offer the employee the full extent of what they can get under an unfair dismissal claim. Important point to note there that, save for sort of some exceptional circumstances which are very unlikely to apply in a redundancy situation, employees will generally need 2 years continuous service to bring in a claim for unfair dismissal. So, some employers might take the sort of commercial approach of just getting rid of those employees who don't have 2 years service. I would generally advise against that on a sort of blanket basis. I think if you just do that as a sort of almost on a policy basis, and you're a big employer, for instance, you could open yourself up to an age discrimination argument, as those employers that have the least length of service are likely to be younger. So there are risks that come with that. That said, there might be certain circumstances where, yes, you can maybe cut a few corners where the employee has less than 2 years service, but that doesn't detract again from the fact that you should be doing all you can to again comply with those areas around selection, consultation, and redeployment when you're tackling your redundancy dismissal. So just bear that in mind. Not uncommon then for unfair dismissal claims to also include claims for discrimination. I've already touched on sex discrimination, disability discrimination type claims. They can be typically more high value in nature. So you've got one component of that would be an injury to feelings award. So that's based on a banded system, depending on the severity of the act of discrimination. So you've got 900 to 9,000 for the less serious cases, 9,000 to 27 on the mid-range cases, which are sort of more than one-off, but seen as sort of sufficiently serious to be in that mid-range. And then the more serious cases, you have 27,000 up to 45,000 on the injury to feelings element. So they can be quite stiff in terms of the claims, the discrimination claims. And bear in mind, unlike unfair dismissal, compensatory awards will be uncapped in terms of the loss of earnings element as well. So, that's just worth bearing in mind, I think, in terms of your potential liability on those areas. Protective awards, again, I've already touched on that. You've got your potential 90-day award. And the thing you need to look out for on that one is it can lend itself to multiple claims. So you've got X number of employees issuing claims against you, which could lead to quite a heavy liability on the protective award. So again, it's just covering that, making you aware of that. That really concludes then the presentation, the seminar presentation, which I hope you found useful. I've left my contact details there, so happy to take any questions now, or alternatively, if you want to sort of get in touch directly after the webinar, feel free to do so. Equally, if you want to sort of copy around the slides or anything like that, I'm not that precious about that. So feel free to get in touch, and I'll be quite happy to send you those across. And thanks very much again for attending. And I'll pass back to Nicola now if we've got any sort of questions.
don't think we've got any questions come through on the chat, unless anybody wants to ask any live. I just give a minute just to see if there are any. I don't think so. First of all, I just want to say thank you so much, David. That was really, really useful. Such practical tips to be able to follow and everything. And if you can send the slides over to me, I can send them out to everybody that attended today. Thanks everybody for watching, and hopefully we'll see you at another webinar soon. Thanks everyone.
Thank you.